What's up, everybody? So we're back here again at the federal court building. We're gonna hit the late night drop box again and put this motion to dismiss in there, and then after that we'll jump into a reading of the brief from the federal government, basically their case in this instance, and our motion to dismiss, and then I will also link the documents in the bottom of the video here so you can read along with me. So everybody should go pull that up on their screen for after we drop this off. We'll jump in to the reading of that motion to dismiss so you can see what it was. This is a great collaboration between some Lions Den members, and you know, we all worked hard on this thing, and I think it looks spectacular. So I'm very impressed, and I hope you will be as well, and hopefully maybe the judge will be. Here we are, no smoking area, late night drop box again. All right, so my phone down. And let's see here. I'm gonna stamp each one of these. I got one for myself and one for Mr. Gerhard, and I got Exhibit A. If you haven't seen Exhibit A, it was the upload just prior to this. It's the instance of the arrest, about 8 minutes. So yeah, let's just do this thing. Date and time stamp. I'll do both sides. So I like to do the front and the back. Boom. And take this, and I'll stamp the envelope. Keep everything together. Okay, drop it in there. Zoom. Got the document depository and the date and the timestamp. So we're going to jump into breakdown and reading of the brief from the federal government and our motion to dismiss. Hope you guys like it. Thank you. All right. We're live. So, what's going on, everybody? What?
That's where the sound's going.
For you? Yep. Oh, so you want me to talk first?
Well, I'm just saying it's not gonna. I guess it doesn't matter. You still.
It doesn't matter. Yeah, it's still.
Anyway, so yeah.
So what's going on, everybody? We're testing out some new equipment here that Mr. Gerhard has, and we're going to update you all on the state's, or well, it's not the state, it's the federal government's case against us for recording in the lobby. This is their brief trial memorandum here that we have, and I'm just going to read it to you. The defendants, Jason Gerhard and Frank Staples, were assessed citations by a federal police officer for violating 41 CFR 385, insofar as they failed to comply with directions from the officer. The defendants are seeking a trial. The basic facts are straightforward. On September 11, 2023,
the defendants came to the Warren B. Rudman Courthouse to observe the federal sentencing of Ian Freeman. On entering the building, the defendants began electronic recording of the courthouse interior. Such recording violated United States District Court Local Rule 83.8, which, subject to certain exceptions not applicable here, prohibits all persons from photographing, recording audio or video, broadcasting, transmitting, or televising within the Warren B. Rudman U.S. Courthouse. This local rule applies to criminal cases. See New Hampshire Criminal Rule 1.1d. The local rule prohibiting recording is posted at the entrance to the Rudman Courthouse. Also posted at the courthouse entrance on the right side wall in front of the magnometers is a copy of 41 CFR .385, which provides that persons in and on property must at all times comply with official signs of a prohibitory, regulatory, or directory nature, and with the lawful directions of federal police officers and other authorized individuals. Upon observing the defendant's efforts to record the Rudman Courthouse, Federal Protective Service Officer Michael Plant approached the defendants and informed them that their conduct violated the local rules and asked them to stop recording. The defendants refused. Officer Plant then asked the defendants to leave the courthouse. The defendants refused. Thereafter, Officer Plant and another officer placed the defendants in handcuffs. The defendants were processed, provided a citation, and escorted from the courthouse. The defendants were we escorted? I don't recall being escorted from the courthouse.
I don't think so.
The defendants placed their recording devices in their cars and were allowed to re-enter the courthouse. The exchange between the defendants and Officer Plant was video recorded and uploaded to YouTube. Oh, why wasn't it on their body cams? So the United States is proceeding in this matter as a petty offense. This is important here. So they're charging it as a petty offense in which it is only seeking that a court impose a fine. The court should announce prior to the trial that it will not impose a prison sentence in the event of a conviction. Doing so makes compliance with the federal rules of criminal procedure discretionary. And that's really not a complete sentence. I'm not sure exactly what that means. He cites United States versus Killington. It also would make clear that the defendants have no right to appointed counsel. And so this is what they're doing. I don't know if you realize this. They are saying, we're not going to give you guys any prison time, so you don't get a jury trial and you don't get counsel. And so that's why the prosecutor here is asking the judge to make a statement saying that we're not going to get prison time. So it would also make clear that...
Hold on a second. Well, also, it has to do with the fact that then you don't have trial by jury.
Correct. Yes. Same thing. Yes, they're both... Yes, that's the argument. And they're saying the courts disagree on whether a defendant has a right to appointed counsel in a petty offense case where the judge has not committed pre-trial to impose a non-incarcerative sentence in the event of conviction. So if the judge doesn't commit to not sending us to prison, then we are entitled to counsel and a jury trial. So I expect, if it does go to trial, she will make some sort of statement how, regardless of the outcome in a conviction, I will not be imposing any sort of incarceration to cover their butts. So it says, therefore, the last page here. Before trial, the court should state on the record that it will not impose a prison sentence to resolve any potential issues about the right to appointed counsel, appeal issues, right? Turning to the merits of the charge, to prove a violation of 41 CFR 385, the government must establish the following elements. 1, an incident occurred on federal property. If they can't prove that, nothing else matters. If they can prove that...
Hold on a second. I'm so confused. What are you reading and what are you talking about?
This is this...
I know, but I can't tell when you're segueing from one to the other.
This is still the... this is the what is it, second to last paragraph on
Like, you've just been reading it verbatim?
verbatim. I've been reading it
Oh,
verbatim
I
and chiming in here and there with stuff, but this has all been verbatim most of it.
Okay.
So I've been explaining, the prison sentence thing, right?
Mhm.
So he's saying, turning to the merits of the charge, to prove a violation, the government must establish the following elements. There's 3 elements. The incident occurred on federal property. 2, the defendant failed to comply with either 1, an official sign of a prohibitory, regulatory, or directory nature, or the lawful direction, and this is what they're saying, the lawful direction of the federal police officers or other authorized individuals. Of course, we know it wasn't lawful. 3, the defendant acted unlawfully, willfully, and knowingly. Last paragraph. The evidence here will demonstrate that the defendants are guilty of violating 385, the local rule against Guilty of violating 385, the local rule against recording in the courthouse, and the requirement to follow federal police officer instructions were conspicuously posted in the courthouse entrance, where the defendants attempted to record. The defendants attempted to record and disobeyed a federal officer's order to stop on federal property. The command from the officer to stop recording was direct, and the defendants willfully and knowingly disobeyed the order. And so that's it. And real quick, it was different. I don't know exactly what they said to you, but I do know the only thing he directly said to me after they arrested you was, do you want to get arrested? Or do you want to stop recording and leave the building? Or do you want to get arrested? To me, that's a question, not a direct statement. He should have, and I mean, I've seen tons of videos, you say, sir, I'm instructing you, I'm ordering you to leave the building and stop recording. And maybe do it 2 or 3 other times.
I just don't see that as being that
That's
big of a
how,
deal.
no, it has to be direct. That's why he says it was direct. There was a direct statement. No, the command has to be clear and direct.
Yeah, but okay.
If
So be
it
it.
goes to trial.
So be it, but even still, to me, it's the bigger issue. It's just transparency in the courts. No matter what magic words they make up, it's all bogus anyway.
Oh, well, yeah, of course.
Do you know what I mean? Like, if he didn't say, oh, directly, you must leave, who cares if it's abracadabra or abracadoo? It's the general principle that we can't be recording in these places. So, for instance, our first appearance, I had to pay $35. 35, maybe it was a little more, a little less. No, I think it was, okay, it's somewhere thereabouts, for a CD of that 10 minutes recording, or whatever the hearing was. It was like 15. But yeah. Why couldn't I just record it with my own device?
Because it goes through the stenographer.
No. I talked to the court.
Do
The
they not do that?
magistrates' hearings are
Audio.
recorded unless what's the caveat? Basically,
Oh, yeah, because you got the audio.
no. Well, I talked to him on the phone. I mean, it was. If
But
they're
you
just
brought the
doing-
audio of
If the
it.
magistrate's doing a jury trial, I think that's how it works. They have to get the transcripts. It has to be transcripts, and there's no audio. Just weird.
What?
Yeah,
So there's no audio on a jury trial
there is in the
There-
magistrate.
in magistrate. But there's not on what we did.
That's a magistrate.
That was a magistrate. So is it on audio?
Okay, hold on a second. What I'm saying is a magistrate is something you consent to. So you consent to seeing a magistrate because they have, this is interesting, and this comes into another legal thing, but every federal district has certain attributes, and one is a fixed number of judges because they're commissioned or well appointed, I'm sorry. So New Hampshire has 3 in order to fill up the roster because they have so many cases they're not supposed to be hearing, because since only piracy and counterfeiting on the high C, counterfeiting and piracy on the high seas are the only 2 federal crimes listed. Oh wait, 3. What is the other one? Treason,
Treason.
right? Isn't that? But anyway, let's look at what Bear was saying because I think that's interesting.
So that's that. That's what the federal government is, staking. That's the hill they want to die on, apparently. And so we filed motions to dismiss. Bear helped out immense, like he did all the this thing looks like an attorney
It's professional. Thank you, Bear.
put it together.
Appreciate
Amazing, very articulate, and with the footnotes and case law to back it up and all that stuff. So amazing job here. And this is what it says. So I, Jason Gerhardt, Frank Staples, am one of the people and a citizen of New Hampshire residing in Hillsborough County. I present myself sui juris in my own defense and respectfully move to dismiss one count of CFR 41 CFR 385 for alleged failure to conform to official signs and directions concerning photographs for news and advertising or commercial purposes, as described by 41 CFR 102.74.420. So 420 is the one that governs this. This motion to dismiss is based on the government's failure to prove the essential elements and also as an as-applied challenge to
Hold
the
on a
rules.
second. I'm
imposed.
confused.
Mhm.
I present myself sui juris in my own defense and respectfully move to dismiss one count of 41-385
That's the disobeying that we were charged with.
is alleged failure. So why do you say the 420 is the one that's...
Because so they're saying we disobeyed to disobey, you have to be disobeying a rule. Something else, right? So what were we disobeying? They said it was about photography,
Yeah.
right? And recording. And the rule governing that says we're allowed to do it,
Okay. Yeah.
right? So,
let me read the footnote on the
Sure.
District of Columbia. This is something I learned recently through Dave Jose and company.
And this is for, tell them what word it's footnoted on.
Yeah. So the important concept is we the people. It's tricky. The more I think about it, the more it makes sense. When you go into court, you'll have certain people that tell you you have to claim to be a living man, woman, and all this stuff about the birth certificates and a lot of other
Magic words.
I will say there's probably a lot of truth to that, and I've seen some little tidbits here and there. But at the same time, if the federal government and through the Supreme Court says that we the people is a higher term or a higher status, then I think we should see what they say, unless you think it's a setup, and I don't know, but I never see any proof of these cases that people are being living men and women. Although I guess there are cases here and there.
I don't know, I haven't seen it. I've been asking, somebody actually sent me a message recently, who was saying, I was like, listen, I want to see proof, I want some videos, what are the questions, like, I want to see some stuff, because I've tried some of these, we're doing it, we're in the courts, like, putting this stuff to the test. So if it works so well, like some of this driving stuff too, because there's people charging thousands of dollars for this supposed information and magic words on how you can travel freely without a license and all that stuff, right? And if it works so well, then why aren't there more videos of it all? And, so I don't know. I'm dubious. I'm open, to it all. If it works, show us.
Yeah.
Show us that it works.
Oh, so real quick, we the people. I'm sorry. Yes, we the people. Or
One of the people?
Or the people.
The people.
So District of Columbia versus Heller, says 2008 Supreme Court case. The term people unambiguously refers to all members of the political community, not an unspecified subset. As we said in United States versus Verdugo Urquidez in 1990, the people protected by the Fourth Amendment and by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and Tenth Amendments, refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community.
So it's very broad.
It is, but at the same time,
It doesn't
I
mean you're-
think simplicity wins the day with this. You don't have to claim to be many more things than a
Right.
child of God. We're all made in His image. Why are you trying to lord over me and be some kind of tyrant? That's what it really. So.
Exactly.
Okay.
I agree, 100%. That's a big case, the Heller case. It's a landmark.
Can't claim read it, but reading this stuff is so torturous.
It's tough.
But this is at least good because Bear just goes through it point by point and just knocks it all down.
Yeah. So, in order to convict under 41 CFR 385, the government must prove each element of the crime beyond a reasonable doubt. All those elements we just went over earlier. The three elements of the offense are, like we said, the incident occurred on federal property, that the defendant failed to comply with an official sign or the lawful direction of an officer, and that the defendant acted unlawfully, willingly, and knowingly. United States vs. Rated. For the first element, although we're not disputing that the alleged incident occurred on or at 55 Pleasant Street, Concord, New Hampshire, the government has not shown this to be property belonging to the United States. See Article 4, Section 3 of the United States Constitution, over which Congress shall have the power to make all needful rules and regulations. In fact, legal control and jurisdiction over this property has not been ceded to the United States from New Hampshire because an accurate description and plan of the lands so owned and occupied has not been filed with the Secretary of New Hampshire as required by New Hampshire RSA 123.1, where the government has not met its burden of proof beyond reasonable doubt by producing any document which satisfies RSA 123.1, there's a defect and the charge must be dismissed. So unless they come up with a document, and we're going to the archives, specifically for 55 Pleasant Street, I already put in the order. I'm gonna see, what's today? Saturday? So we'll see on Monday what they find.
Well, I got a certificate back in 2018 certified to this effect. So
Right.
they had never filed with them, and it makes you wonder about property taxes too.
Well, yeah, I mean, this could be a huge can of worms here if they haven't filed for a single federal piece of property in the state. Then
But imagine how much you could fund schools with that property taxes, property tax relief right there.
So, as for the second element, failure to comply with official signs or unlawful direction of authorities. Lawful direction of authorities, thank you. The record clearly indicates that a sign entitled Rules and Regulations Governing Conduct on Federal Property was the only guidance at the door of the property. The text of 41 CFR 420 is quoted verbatim in this document, which the federal prosecutors are conveniently leaving out of their case. Photographs for news, advertising, or commercial purposes, 41 CFR section 10274.420. Except where security regulations, rules, orders, or directives apply, or a federal court order or rule prohibits it, persons entering in or on federal property may take photographs of, and then we go to C, building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. So you're allowed to film all those areas. You have to get permission to film in a space occupied by someone because that building is not the courthouse. There are courtrooms and those are considered the courthouse. That's a court building complex that houses a lot of other stuff in there. So to continue, the government accuses me of recording the courthouse interior on the day when many other interested people came to witness and to report on the sentencing of Ian Freeman. But the posted 41 CFR 10274.420 plainly states, except where security regulations, rules, orders, other directives apply, federal court order, you may take photographs of the building entrances, lobbies, foyers, corridors, and auditoriums for news purposes. And I was doing just that. The charge must be dismissed as to punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort. For while an individual certainly may be penalized for violating the law, he just as certainly may not be punished for exercising a protected statutory or constitutional right. United States v. Goodwin, 1982.
All right, let me pick up here.
Yeah.
The government's assertion that my conduct violated local rule 83.8 is erroneous. Firstly, these rules weren't posted for the public to see. Only the sign entitled Rules and Regulations Governing Conduct on Federal Property, quoting the text of 41 CFR 420, was actually conspicuously posted, of which I have numerous photographs. And secondly, even if it were posted, Local Rule 83.8 are the rules of court which govern the procedure in all civil actions. See Local Rule 1.1F, local rules.
They cited 1.1D. They didn't go to F, which is the scope of all the rules. It's
Yeah.
only civil.
That's interesting.
Mm-hmm.
So now because we are paying a fine, that's what makes it a criminal case.
Correct. And because the potential for jail time. Because there still is the.
Well, that's what I'm saying. So civil, the thing with civil is you can't be you cannot be
Well,
imprisoned.
I'm not gonna. Yeah. No. I don't
Civil
think.
case?
I don't think that's. No, it just means it's a non-jailable criminal thing. Still a criminal case. It's a petty criminal case.
I don't think so.
Yes. Because it's
You're
technically.
telling me, so in a civil case you can get fined. You can't get imprisoned.
Correct, but that's why in this thing, the prosecutor was like, I'm asking the judge to make an order that you're not going to impose prison time, because they can up until, even if they said, I'm not going to impose prison time, and then afterwards like, I changed my mind. They could. We could face 1 to 5 years. And I'm not going to lie, I didn't realize, I assumed this just like this is some like what are they? You're gonna put us in jail? You want to put me in jail for that? Go ahead. I dare you. Freaking dare you. So, yeah, where were we?
Local rules 1.1, 83.17 shall govern the procedure in all civil actions.
Mm-hmm.
And furthermore, it extends to persons participating in the court proceeding. Obviously, I was not involved in a civil action. I was not a participant in a court proceeding, where evidence will show that the government has failed its burden to prove that 1, these rules were in fact conspicuously posted, and 2, that the rules governing civil procedure are specifically to me. There is misapplication of the law and the charge must be dismissed.
And then for the third element of the accusation that I willfully and knowingly failed to comply with the lawful direction, qualifying term here, lawful direction of a federal police officers and other authorized individuals, is contradicted by the evidence, and that the text of 41 CFR 420 posted at the entrance that they reference to, stating persons entering may take photographs of the lobbies and foyers and corridors. I could not willfully and knowingly violate an order which I had good faith to believe was contrary to the posted law, right? Merely the play and action of purely personal and arbitrary power. Yickwo versus Hopkins, 1886, excuse me, it's an old one, where the evidence clearly shows that there were blurred signposts to criminality. The charge must be dismissed because the government cannot meet its burden of proving beyond a reasonable doubt that my actions were in fact done willfully or knowingly. You want to do that as applied?
With some limited exceptions. So this is an as-applied challenge. I didn't know what it was. With some limited exceptions, when the constitutionality of a statute is challenged, the question to be decided is whether the statute is unconstitutional as applied in the particular case.
So basically, the rules on their face are constitutional. The way that they applied them by saying, we're giving you an order and this says that you have to follow our orders, but you can't tell me that I'm not allowed to follow rules. They were basically telling us, you're not allowed to follow the rules.
No, but that's not what's going on right now. He's saying when the constitutional statute is challenged, the question to be decided is whether the statute is unconstitutional as applied in the particular case.
Correct.
So you're saying that some of this stuff, it was only
it's just
applied, it's not really unconstitutional. It's all unconstitutional.
No, the fact that they're not allowing us to go and record, yes, that's unconstitutional. But the rules as they are read say that we're allowed to do those things. So they should be allowing us to do those things. They're not doing it. So the rules as they read are constitutional. It's just the way that they're applying the rules are not constitutional.
Okay, I see what you're saying.
You know, on the books, everything looks good, but then when you go to try to do these things, they're like, oh, you can't film in public. This is a limited public forum. This is not the same as, even though it's 100% a public place. And you look at, it's a theme, and it's part of the culture of law enforcement in general, and they just want more and more control. And so you look at their rule for the IDs. That is for staff members, and so it's not for the public. They want the public, and they say you're not allowed, and they don't identify employees as they come in, but they want to identify and say you're not allowed in without an ID. That violates your Fourth Amendment. Public should be able to go there free. Because look, we all attend Ian's sentencing, and then they're saying you're part of this organization because you attended his sentencing. You know, they were like, and they're trying to use his video that he used from, our video that he put together and try to make some sort of links and connections. So they want all this information and data that, they want to know every single one of those people that came in there to that sentencing that day, 100%.
All right, so U.S. versus Ferrara, 1991. Since, quote, a facial challenge to a legislative act is, of course, the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exists under which the act would be valid. U.S. versus Salerno, 1987. You want to keep going?
Yeah. All right. So 41 CFR 385, that's following orders thing, is challenged as applied to my personal right to make records of myself for my own memory, happiness, safety, and for news purposes. So not just for my own personal purposes, but also for news purposes if I so choose, right? The power to, but you gotta, because they're trying to pigeonhole it into this news commercial thing when we also have a right just for our own personal records. And I should be able to, anywhere I go, I can record all I want, body cam on all day long, 24 hours a day, unless I'm start to go into private places where people won't allow that. Otherwise, I should be allowed. So the power to keep a record is an authority that I and other people have delegated to the government and the courts to safeguard my security and to regulate photography for advertising or commercial purposes. But my grant of this authority was never intended to detract from my personal or constitutional rights, which are at all times jealously guarded. That is, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with me and the people, by whom and for whom all government exists and acts.
Yeah, that's so key.
That's again that 1886 case, Yickwo versus Hopkins. And of course, we the people are exempt from prosecution for the exercise of our rights because there can be no legal right as against the authority that makes the law on which the right depends. A suit presupposes that the defendants are subject to the rule invoked. Of course, it cannot be maintained unless they are so. Do you want to?
Yep.
In the present case.
In the present case, officers illegally deprived the claim and exercise of my peaceful and personal right to record myself and for news purposes under the color of rules that apply to advertising or commercial purposes. Their unlawful conduct was not grounded on clear and unequivocal posted law, but on the willful misapplication of blurred signposted criminality and the play and action of purely personal and arbitrary power, which this court has a duty to correct and strike down. For all the foregoing reasons, this case, alleging a violation of 41 CFR 385, must be dismissed. He did a great job on this.
Yeah, I think it's a banger.
So real quick, going back,
And then we have
footnotes.
Hold on, we have, so people can see. There's a picture on the,
There's no way you're gonna be able to see that.
no, they're not gonna, but that's the poster And down here, I circled it on the ones we filed. I circled the part that it says for photographing where we're allowed to do it.
So going back though, the footnote on page 5 was people. In constitutional law, this is definition. In constitutional law, the entire body of those citizens invested with political power for political purposes, the qualified voters or electors, the repository of sovereignty, or as the source of governmental power. Black's Law Dictionary, 4th edition, page 1292. That's where the power came from, and that's where the power still resides. It's just a matter of getting some of these
Well, they have the power.
corporations out of the way.
They get their power from us, and if they can record us, why can't we record them? It's that simple. Of course we can. They just don't want us to. Why?
So I just want to mention that I'll post these in the video, well, at least the shots of them, but there's a whole collection of notices that Chris Noyes has been kind enough to help out with, and a whole group of people who follow along with what Dave Jose has been doing around the country. And they've just been great. They've been giving me, whenever I need a rebuttal to anything that the court comes down with, it's immediate, and they know their stuff really well. Using all these law maxims, which are just basically, it's common sense, but it's legal terms. For instance, maximum of law in the first one. It matters not what is known to the judge if it is not known to him judicially, which means you have to provide notice of everything. You can't bring something up that, and this is good. No one is believed in court but upon his oath. So, going through that in Black's Law Dictionary, this is actually what I read at the notice. I'm sorry.
Oh, right. So yeah, people should know that they've been helping. Did I file something?
Because my whole case, I'm going to be arguing this a little bit differently than Frank's going to be. My whole thing is along trial by jury. You arrest me for something that is, even your reputation is considered property. So the fact that they have arrested us and charged us with this constitutionally protected activity is detrimental to my property, my reputation, which allows me to have a trial by jury of my peers, not a jury trial. So there's been some weird administrative switch where we've had our actual rights protected under the Constitution and the 7th Amendment
Abrogated.
Yeah, just totally cut off at the knees under the pretense that we don't deserve all of our rights. And they made justice into a streamlined process. But it's not benefiting anyone because no one knows what's going on. People are taking plea offers, 97% of people.
Mm-hmm.
No, I'm sorry, is that what it is?
Probably more than that. I don't know. It's got to be a lot. I know
that's
that
what they say the federal conviction rate
the
was.
conviction rate.
But that's weird. If you look at it, it's 70% of people that go to trial are convicted. It's 97% overall because so many people take the plea.
Interesting. Yeah, I don't know the numbers exactly, but I know they have a high conviction rate.
Which, whatever it is, should your conviction rate be that high? Is it possible people are that perfect?
No, well, they just cherry pick, and they gather information, and they got their hands in all these operations, whatever they're investigating in. They got their little informed. Look at they were working with Whitey Bulger and shit, bro. Like, you know what I mean? They work hand in hand with murderers and criminals because those are the ones that have the most information. So if you can just work with this one master criminal and then have him give you some of his competition every once in a while, it saves them they don't have any work to do. It's easy.
Yeah.
You know, it just falls in their lap and they're like, oh yeah, let's just pick this guy off now. Let's pick that guy off now. So, and that's 100%, you know, we know that's happened. We know it's fact with that one case. And, I mean, CIA was involved with that guy. He was in prison as well. And they did, you know, psychological warfare experiments on him with psychedelics and things like that.
Who's that?
Whitey Bulger.
Oh, really?
Yeah, because they used to allow the testing of, if you're a prisoner, you could enter into medical tests and get time cut and things like that. and they would just test on people that you'd be like, oh, we want to test it. So they were doing.
I remember it was actually a guard at the federal prison in Ferreton, New Jersey, that was talking about a Puerto Rican independence leader back in the 50s, 50 going into the 60s, and the Department of Energy used radiation on him. They were experimenting on him, so his skin was burning. He was wrapping themselves in towels because they wanted to see how what kind of damage they could do to humans.
Sick.
But the guy's crime was advocating for Puerto Rican independence.
Oh my God.
Yeah, we're in a really messed up, and they would never test on you with vaccines. Really?
Well, what about the syphilis experiments that
all
they did on the black population, right?
Let me just read this real quick before we go off into nothingness. Because that's a road.
That's all, yeah. True. Look into the syphilis experiments. They had the cure and they were.
Well, not just that, I'm talking about just government. Well, yes.
Well, they were infecting people intentionally.
No, but I'm talking about or even dropping infectious pathogens in certain cities.
Well, Deer Island, the ticks, and the weaponized.
I think it's called Operation Popeye. I think that's what it was. Where they were infecting. Okay, anyway. So getting back to one of the first notices I filed. Take notice that the United States Constitution's 7th Amendment guarantees that any one of the people be afforded a trial by jury moving exclusively by the rules of common law, which that's why my angle is a little bit different than yours. I want to remove myself from all of this statutory law. Statutes affect the government. The government makes rules for the government.
We did raise that at our arraignment, though, right? I did too. The whole, what jurisdiction, what is this? Is this a common law court?
Or are we an
administrative court? And they refused, I wish I had it, I had the trial transcript, or the transcript of it. The judge refused. I don't know what happened with yours. I wasn't in there, but you were in there for mine.
Mm-hmm.
She refused to say it's XYZ jurisdiction. She said, she puts her hands to the prosecutor, and he's like, oh, we would charge them under this and that, and it's like, that doesn't say what jurisdiction this is still. And that's what I said, and she eventually capitulated in a way and said, this is not a 7th Amendment common law court. And saying it's not something means it could be anything else, even though.
Which is, as you said, how do I know what defense to prepare? If I don't know the rules of this,
if I don't know the jurisdiction, how do I? Yeah, exactly. I don't know if I'm playing chess, checkers, Go. What game is this?